So this presentation is not to be considered as legal advice. If you are going through a specific situation with your employer, or you have a question about what you might have experienced, that is a legal question that you should speak to either us at SALCO or your local legal clinic or any other lawyer that practices employment law to get advice based on that specific circumstance. So SALCO, just briefly, is one of Legal Aid Ontario's community legal clinics. We're a specialty legal clinic because we serve anyone who identifies as South Asian in the Greater Toronto area and then more broadly in the province of Ontario. There are other local legal clinics scattered out through Ontario, and they provide practice for specific communities. So like we'll have one in North Peel, we'll have one in Mississauga, there's one in York Region, Durham, wherever you are, if there are local legal clinics throughout those locations. Our specific address is 45 Shepherd Avenue East in Toronto. This is updated. Our office is open to the public during certain hours, and you can call us for legal advice. We also provide services in English, but in other South Asian languages. And then we do have a financial eligibility criteria similar to other legal clinics and LAO, but we try to provide discretion when we can based on, again, your specific circumstances. So to start off this presentation, I want to talk about, what is employment law in Ontario, or what does that mean? Because you might think like, oh, I'm working, so yeah, that's employment law. But in Ontario, employment law is actually your relationship with your employer is impacted by a number of different laws and legal aspects. So one of the main ones that you're probably aware of or will become aware of after this presentation is the Employment Standards Act of Ontario. And we're going to talk about that in quite a bit of detail shortly, but that's kind of your main law in Ontario that tells an employer and an employee what their relationship should look like, what rules need to be followed, what actions need to be taken when you're in an employment relationship. And then that act is for anyone who is a provincial employee. So that's, again, most employees in Ontario. But if you're not a provincial employee, you're a federal employee, you would be covered by the Canada Labour Code, which kind of provides a similar purpose as the Employment Standards Act, but is specific to federally regulated employees. Now, how do you know if you're a federally regulated employee or a provincially regulated employee? You usually turn to what industry your work is in. So if the industry you're working in is federally regulated, then you're going to be most likely a federally regulated employee under the Canada Labour Code. So if you work in a bank, if you work at the airport, if you work in kind of telecommunications, those industries are often, they fall under the federal code. Also, the tricky one is if you're doing any form of kind of truck driving, you could either be provincially regulated or federally regulated. And the difference there is if you're crossing provincial borders or if you're going into the states. So if you cross into provincial borders or you go into the states, then you are a federally regulated truck driver. And if you're only delivering in Ontario, then you're provincially regulated. But outside of that, another common law that you might know comes into play in dealing with your employment relationship is the Human Rights Code in Ontario, or the Canadian Human Rights Act, if, again, you're federally regulated. So that provides you with specific rights that the Employment Standards Act doesn't cover. And then some other big ones are the Occupational Health and Safety Act. And so those are the three kind of laws that we're going to touch upon that impact your employment relationship. But also your employment relationship is impacted if you're unionized or not unionized. So it's important to understand when you get into an employment relationship if you're a part of a union or not. Because if you're unionized, one, you're going to be paying union dues. So that would be a deduction on your pay stub that you should, have knowledge that why that exists. And when you're unionized, you have different rights. You're not covered by the Employment Standards Act in the same way, but also you have an advocate kind of built into your employment, which is your union. And so if you have issues with your employer, it's usually your union that's going to be the first one who kind of is supposed to stand up for you to help you figure out that situation. So we won't be really talking about unionized worker because within the clinic system, we don't really practice in that area of law. But if you contacted us because you're unionized, then we would provide you with referrals for lawyers who are more of an expert in that area. And then the other thing that will impact is contract and court-based law. So your contract that you sign when you get into an employment relationship is really important. It will tell you about your relationship with your employer to a degree, but then that contract also still has to follow the law, and we're going to talk about that in more detail. And then court-based law also comes in, and what a court-based law is that sometimes the government doesn't create a law like the Employment Standards Act, but when other people have had experiences and they take that to court and a judge makes a decision, that becomes a precedent. And in a way, it's a law. So you can go to court if you're in a similar situation and say, I also have these rights because a previous court gave me or gave another employee those rights. And so we're going to touch about that a little bit later too. So it's just a little kind of, there's all sorts of things that get looked at when we talk about your employment relationship. So starting off with the Employment Standards Act, right? Because as I mentioned, that's kind of the minimum legal requirements that all employees should have. And the Act tells employers that they have to follow these requirements at the very least. So in a contract, right, I did mention that your employment contract is important, but if the employment contract tries to go away and give you less than the Employment Standards Act, the courts and the law says, well, that contract is void then. You have to, at the very least, get what is provided within the Employment Standards Act. Now, there are some exemptions, right? So one, this is only for provincially regulated employees. And then two, at different times, different industries have lobbied for exceptions and special rules for their specific industries. So what that means is that even though the Employment Standard Act, for example, says, on minimum, here's the minimum wage. After working 44 hours, you have to get overtime pay. There are rules within the rules that say, okay, well, if you're in IT, for example, or if you're a manager, you're not entitled to overtime pay. So it does provide the minimum, but then some workers and some industries have different minimums. Okay. The government of Ontario has created kind of a document, your guide to employment standards, which is really detailed, and they do a decently good job of putting it into plain language. It's only in English, but it is there as a resource for workers. So now we're going to talk about a few of the, main rights that are kind of in the Employment Standards Act. Like the act in and of itself could be an entire presentation. So we're not going to touch upon every aspect of the act, which is also why I provided you with that information to the link. So you can, kind of explore on your own if you have a specific question or if you're just curious. And then also, again, if you need more detailed advice, you can reach out to a lawyer. But obviously, one of the basic ones is minimum wage. So minimum wage as of October 1st, 2025 is $17.60 for most workers. And then if you're a student, it's $16.60 per hour. Now, the student category, there are specific rules in that. It doesn't just apply to all students, but that is something to note, that there is, again, a difference. And then, as I mentioned, right, there's a lot of exceptions. So there are workers who aren't entitled to the minimum wage, and we do see that as superintendents, janitors, caretakers of a residential building who also live in that building, students who instruct or supervise children, and then commissioned salespeople other than a route salesperson who sells away from the employer's place of business. So those are kind of some three main exceptions. But again, there are a lot and can't cover all of them, which is why, again, it's always best if you have a specific situation to speak to a lawyer. And something to keep in mind is that the minimum wage, if it's going to increase, they announce it in the spring prior to October of that year. So it always generally, if it increases on October 1st, and then the announcement happens in April or May. So hours of work. So daily, you can, the act says that you can only work 8 hours maximum unless there's a regular workday of more than 8 hours or you agree in writing. And then so weekly, 48 hours maximum. And again, unless you agree in writing to do more work than 48 hours per week. Eating periods, you get a 30-minute rest period every 5 hours of work, and that rest period is unpaid. Now, it's important to remember that it only counts as a rest period if you have the ability to leave your work environment, okay? So what I mean by that is if you're working retail and your boss is like, we're short-staffed or whatever, can you just have your lunch while at the cashier desk, right? In that case, that doesn't count as an unpaid break. You should be paid for the hours or the 30 minutes then that you were kind of having your lunch while also at the cashier desk. It's only considered a break if you're actually able to remove yourself from the workplace. And so they must also receive the following time off. Again, at least 8 hours between shifts, except where the total time worked during the 2 shifts is less than 13 hours, at least 11 hours in a row off work each day, at least 24 hours in a row off work each week, or 48 hours in a row off work every 2 weeks. So basically, either you get 1 day off every week, or you get 2 days off every 2 weeks. And then overtime, I kind of already alluded to overtime as a right that's discussed in the Employment Standards Act, but specifically overtime, if you're entitled to it, it's 1.5 times your regular rate of pay for every hour worked over 44 hours per week. Now, so the Act says you can agree in writing to average the hours you work over periods of 2 to 4 weeks to calculate overtime pay. And sometimes this clause is in your contracts, right? And not all workers, or sometimes workers won't read their contracts or they don't fully understand their contracts. So they just sign it. And I only raise this because the law says that, yeah, if you sign it, if you agree, then they can average it. But oftentimes this averaging is detrimental to the worker. And you have the right to refuse to agree to this practice. So if you do note it in your contract, then you kind of can be empowered to actually think through, do I want to agree to this or do I not want to agree to this? And so I'll tell you why it's often detrimental. So if in 1 week you work 45 hours, so for that 45th hour, right, you're entitled to 1.5 times your regular rate of pay. And so I know the minimum wage is higher than 15, but just for easy math, actually, we'll just skip the math. But yeah, so for that 45th hour, you're entitled to 1.5 times your regular rate of pay. Now, if you agree to average it, right, and say you're averaging it over a period of 2 weeks or 4 weeks, let's just say 2, what might happen is that the first week you worked 45 hours, and in the second week, your employer is like, okay, just work 43 hours. So now between week 1 and week 2, you've just worked 44 hours each week, because they're going to take that 45th hour from the first week and put it into the second week. So you're at 44 hours both weeks. And so then you won't receive even a single 1.1, like you won't receive even 1 hour that's at 1.1 times, 1.5 times your regular rate of pay, right? You'll only receive your regular pay for 2 weeks. So oftentimes what that means, I know we used only an example of just, 1 overtime hour, but often when employers know that they're able to average, they're going to try to make it so that it works out, that there's not many overtime hours for you. So it's just something to keep in mind. Vacation. So after 1 year of working with the same employer, you're entitled to take off 2 weeks of paid vacation. So that's after completing that full first year. And then after 5 years, you're entitled to take off 3 weeks. Some things to know is that your employer can tell you when you can take your vacation, right? So you can say, hey, I want to take vacation in November. And your employer can be like, November is really busy for us. You can't take it in November, but you can take it at any other time. So they're allowed to have that kind of pushback. Now, your employer can't make you take your vacation in less than 1 week increments. So again, if you are entitled to 2 weeks, they can't say, okay, you're not allowed to take 1 week at a time. You have to take like only 3 days at a time. They can't make you do that. And if you don't take your paid vacation, then you're entitled to 4% or 6%, depending on if you're in the 2 week or 3 week of your gross wages as vacation pay. Another important thing to know is that even though you're only entitled to paid vacation after 1 year of working, you are entitled to vacation pay from the very first day. So it can get a little bit confusing, but what that means is that, say if you start working and you've only worked there and you don't like it, and you leave, or you find a better job, but you're entitled to vacation pay for those 2 days that you worked. It doesn't matter that you haven't worked there for a year in that context. Okay. Public holidays. Now, public holidays can also be, it's a little bit of a confusing concept. So I'm going to try to make sure we can, I'm going to be as clear as possible. But basically, employees who work their regularly scheduled shift before and after a holiday, a public holiday, and there are 9 in Ontario and they're listed at the bottom, they're entitled to take that public holiday off and be paid public holiday pay, which is your regular wages for the 4 weeks prior to the public holiday divided by 20. So this is a great timing for this presentation because Monday is a public holiday. So now if you are working and you're regularly scheduled to work on Friday, so today, and you're regularly scheduled to work on Tuesday, and you do, then for the Monday for Thanksgiving, you should be off, and you should receive whatever your past 4 weeks of regular wages was divided by 20. Or, so that's one option, and that's kind of the most common option. Or you can, again, agree in writing to work on the holiday, right? And we see this a lot in retail, at restaurants, things that are open on the holiday. So now if you agree to work on the holiday, you have 2 options. So the first option is that you would still receive that public holiday pay, which is, again, your regular wages for the past 4 weeks divided by 20, plus premium pay for every hour that you work on the holiday, which is 1.5 times your normal rate. Okay. Now that's option 1 if you work on the holiday. Option 2 is that you just get paid your regular wages for that day, not at 1.5, and you receive another day off. So say October 31st, you would get that one off, and you would receive public holiday pay for October 31st. Okay, so hopefully that made it clear. But basically, there's three main options that can happen for public holidays in regards to how much you get paid. Leaves of absence. So the Employment Standards Act provides you with different leaves of absence. And I believe a new one has just kind of started. Um, some of the more common ones are listed. But again, if you are in a particular circumstance or a particular situation, you should check the Employment Standards Act because there might be a leave associated to that you might be eligible for. So again, the common ones, you have a sick leave, where you get 3 unpaid days, family responsibility leave, 3 unpaid days, a bereavement leave, which is 2 unpaid days, and bereavement leaves are generally for if a family member has passed away and you need time to grieve or attend the funeral. Pregnancy leave, right? So if you're pregnant and you're unwell or you need like bed rest, that. And then parental leave is for when the baby's actually born. Generally speaking, each of these leaves have their own, like outside of the 3 unpaid days, the 3 unpaid days, 2 unpaid days, they have different timelines, and you have to be working at the employer for a certain amount of time. Usually it's about 2 weeks, and then you're eligible for this leave. Now, the benefit of these leaves are that they're job protected. So that means that when you come back from the leave, you are coming back to the job that you held already. And it means that if that job is not available for whatever reason, especially for one of the longer leaves like parental leave, they're going to find you a comparable job. And you have the right to be free from penalty if you take any of these leaves. You get to continue in all of your benefit plans that exist when you're on these leaves, and you continue to earn credit for length of employment, service, and seniority. So what that means, right, especially again for the longer leaves, is that like for parental leave, if you're away for a whole year, 12 months, when you leave, you might have worked there for 10 years. And when you come back, it's not that you're coming back having only worked there for 10 years. You come back, you've worked there for 11 years because that time that you were off is still counting towards how long you've worked with your employer. So that's just something to keep in mind. And then another big important aspect of the Employment Standards Act is termination. So termination is sometimes referred to by different words, right? We might not have heard of the word termination, but maybe we know that someone is dismissed or someone's fired, someone's laid off. Those are more kind of common words that we're used to hearing. So in Ontario, other than very few exceptions, an employer is typically free to terminate employees for any reason and are not required to provide employees with a reason for termination. A lot of workers, when they hear this, they get very surprised. They don't understand, right? They often call us and they're like, but I didn't do anything wrong. They didn't tell me why I have to leave or why I'm being fired. They just fired me. And in Ontario and pretty much all over Canada, that is allowed. It's just that if they're going to terminate you, the act tells them that they have to provide you with a certain amount of notice or pay in lieu of notice. Otherwise, they're allowed to terminate you. When we say that there are some exceptions, the only exception is they can't terminate you for a discriminatory purpose, right? So if there's a protected ground, like they can't terminate you because you're a woman, they can't terminate you because you're pregnant. There is a protection there that you get through the Human Rights Code. And there are also remedies, which we'll explore in a bit. If they have a good reason, right? And employers, if they have a good reason to terminate you, they'll let you know because then they don't have to provide that termination notice or severance pay. And that good reason legally is what we understand to be willful misconduct. So willful misconduct means that you intentionally, you purposefully did something that you knew would be against the rules, that would harm the company, right? Like you intentionally stole money from them, you did something really awful that you knew this was going to be a problem. Willful misconduct is not that I was late 4 days in a row. Now, later on, we're going to talk about something called just cause. And again, sometimes workers get confused between willful misconduct and just cause. There are two separate thresholds, you can say. And willful misconduct is the highest threshold. So basically, you are going to be entitled to some form of notice or pay for your termination unless you really hit that high threshold. Termination can also include things like a constructive dismissal and a layoff for more than 13 weeks in a period of 20 consecutive weeks. Now, just briefly, a constructive dismissal is when your employer creates a situation or circumstance that you feel like you can't, keep going with, and so you quit. And even though you're the one who's saying, I have to leave, I'm quitting, because they created the circumstance, you can go to the Ministry of Labor, you can go to court and say, actually, I was constructively dismissed. Now, when we look at what kind of circumstances those are, it's usually if they've changed a fundamental agreement that you've had, right? So if they agree to pay you $20 per hour and they cut that wage to $10, that would be a fundamental change, which could amount to a constructive dismissal. Or if they cut your hours, right? You were on average working 10, 15 hours a week, and then all of a sudden you're not getting any more shifts. That could be considered a constructive dismissal. Now, one thing, and also in that we do see sometimes, like a poisoned workplace, they were harassing you, or some worker was harassing you and the employer was not doing anything. That could all be a constructive dismissal. Now, I would just suggest you get legal advice before you try to engage in the constructive dismissal argument, because they can be tricky to make, right? So if you think that you're in a situation where they're changing your employment contract terms or you're in a poisoned workplace, I would get some legal advice before you take any action. And this includes signing any changes to your employment contract, right? Because that's one factor for a constructive dismissal, is that if they say, okay, we're changing your salary, we're cutting it in half, and you accept, and they make you sign something saying like, yeah, I'm going to continue to work even for this less salary, then they have an argument saying that, oh, actually, this person actually accepted, so they haven't been dismissed. So you don't want that situation. And then the layoff for more than 13 weeks, that's kind of basically they've gone past the temporary layoff. The Employment Standards Act does have rules around when an employer can temporarily lay you off. And if they surpass those rules, then it would be a termination. Now, another thing to keep in mind is that you don't have to agree to terms about temporary layoffs, but it's, again, often in contracts. And it's if you accept it in writing, then they're allowed to temporarily lay you off. So just something to keep in mind. Now, so I mentioned that if you are being terminated and there's no good reason, then they have to provide you with termination pay or notice. And under the Employment Standards Act, because it is a very minimal system, they just have to, it's a very black and white calculation. It's based on how long you were working with your employer, how much notice you receive. And then if they don't give you notice, they have to give you the pay for that many weeks. So less than 3 months, none. And then basically after 3 months, it starts at 1 week and it increases up until 8 weeks. Severance. So oftentimes workers use termination and severance interchangeably. And they are, as concepts, very similar concepts. So I can understand why. But basically they are, under the Employment Standards Act, separate things, because not everyone is entitled to severance. So individuals are only entitled to severance after they've worked for 5 years, and the employer has a payroll of 2.5 million annually or more, which is pretty much amounts to about 60 plus workers okay? If you're entitled to severance, then you'll receive approximately 1 week per year with partial entitlement for months, okay? So if you worked 10 years, you'll get 10 weeks. But if you've worked 10 years and 2 months, you'll get 10 weeks at point something for those 2 months that you worked. That maxes out at 26 weeks, okay? So just briefly, I'm not going to talk too much about this, but temporary help agencies, the main thing is they can't charge you for a fee for attempting to or connecting the worker to a job, assisting with any preparation related to the job, and they're not also allowed to prevent you from actually entering into an employment relationship with the client post whatever the temporary agreement was. They have to provide you with 1 week's written notice or pay in lieu of notice if an assignment is terminated before the end of its estimated term, if that term was for 3 months or longer. So not a lot of people fall into that category, but it is something to keep in mind. And then beginning on January 1st, 2024, there's more regulations around temporary help agencies. So they were required to have a license to operate. They're prohibited from knowingly engaging or using services unless the agency holds a license. Recruiters will be required to have a license. So that's hopefully to help regulate that industry. Employment Protections for Foreign Nationals Act. So this is a separate act that exists in relation to the ESA, but is separate. And so again, it prohibits recruiters and employers from charging you any fees or recovering any costs included related to hiring you, taking your property and documents such as your passport or permit, penalizing you for asking about or asserting your rights under the Employment Protection for Foreign Nationals Act. So how would you enforce your rights if you know that your employer is not doing any of these things, right? You can file a claim with the Ministry of Labor unless you're represented by a trade union, right? I mentioned that there's a big exception if you're unionized, then you have to kind of go through that process. Or if you've already filed a claim in court. So the Ministry of Labor kind of makes it easier for workers, especially unrepresented workers, to pursue their rights. But there might be additional rights that you can only get at court because, again, the Employment Standards Act only focuses on what the act allows for. They're not going to give you anything more, and we're going to talk about why that matters. So sometimes it's a decision of which avenue is best for your case, and again, a lawyer can help you navigate that. You can also call the Employment Standards Information Center for assistance to identify and resolve problems. If you're not sure, the claim form is online, and you can submit it via PDF. Another important thing to note is that you have to file the claim within 2 years of the violation, right? So sometimes for practical reasons, workers will wait till they're let go because even if you make a claim, you're not supposed to be penalized by your employer. There is that fear that you might still get penalized. And sometimes it does happen, practically speaking, that an employer, you'll file a claim, the employer will fire you, and then you can only make an additional claim to say, well, they weren't supposed to fire me. So sometimes workers will wait because, again, it's often important for people to maintain their employment. Which is fine if you're going to wait, but you just need to know that, if it goes beyond 2 years, then potentially you might not be able to make a claim for everything, or that can impact how much you're able to claim. So now we're going to talk about wrongful dismissal. And so this is very much related to the termination piece that we were talking about a few slides back. And it's also related to that bubble that I was telling you about at the beginning of our presentation when we talk about contracts and court-based law. Because wrongful dismissal as a concept comes from that court-based law, and the remedies that exist, what your rights are, all come from those court-based decisions. So as mentioned, right, the principle is the same. An employer can dismiss an employee as long as the employer gives the employee enough advance notice of their termination or pay instead of notice. Now, I told you that an employer can only, like, the employer has to provide termination pay unless the employee engaged in some form of willful misconduct, right? Now, in wrongful dismissal, the threshold for when you're not entitled to wrongful dismissal is not willful misconduct. It's actually called without just cause. So if you're dismissed without a just cause, you must be provided that reasonable notice or pay instead of that reasonable notice. Now, if you're fired for just cause, you won't be entitled to wrongful dismissal damages, right? That reasonable notice that we're about to talk about, but you will be entitled to termination pay under the Employment Standards Act, okay? Because just because the employer is saying, I have just cause to terminate you, doesn't mean that they have proven that you were that there was willful misconduct about what you did. So earlier I gave you the example, right? That if you steal money, that might be willful misconduct. But if you're late, that's not willful misconduct. Now, if you're late multiple times and it's a pattern and your employer talks to you about, well, why are you always late? I need you to be on time. They put you on like some sort of improvement plan. They give you 3 months to improve. You still don't. Um, and like, they keep working on it. They keep giving you warnings. Nothing changes. You still come late too many times. They could dismiss you for just cause, right? They might have an argument. But they would still have to give you whatever you're entitled to termination pay under the Employment Standards Act, because those are two separate amounts of money. Just cause can be, willful misconduct, disobedience, willful neglect of a duty. That's not trivial, right? Again, it can't be something small that you forgot to do, but it could be like, I forgot to lock the store when I left. Like, that's a pretty big deal. It could lead to pretty big things. And also with just cause, there has to be that element of there's an opportunity to improve. You received warnings, maybe you like received a review and like were given a chance to improve. Generally speaking, even if you've done something wrong, like you left the door open, that might still not be enough the first time, right? It really depends. The problem with wrongful dismissal is that it is not black and white like the Employment Standards Act. It is a lot more gray, and it really depends on what specifically happened in your circumstance and what other cases might have happened prior that we can compare your circumstance to say this was like this does amount to just cause or it doesn't amount to just cause. And what you'll see in wrongful dismissal cases is that your lawyer, if you have a lawyer, will be arguing why it wasn't just cause, why you should be entitled to the maximum amount of reasonable notice. And the other lawyer, your employer's lawyer, is going to be doing the exact opposite. And then it comes down to a judge deciding. So when we talk about then how much are you entitled to, because as you might have guessed, it's not black and white. There's no, okay, you worked for X amount of time, so you're going to get X amount of pay as it was in the Employment Standards Act. They're going to look at a variety of factors, right? Length of service is one of them, but also your age, the availability of similar employment at that time, and the character of your employment. And when I say character of your employment, it means like, were you an expert? Were you high up in the employment chain in that particular employee, like in that company or at that job? Or was this kind of a typical job that almost any other person can kind of do, right? So character of employment could be like, I'm a specific expert that only I know the research to take on this task versus a server. So they look at those factors, and now the average award for all occupations. Again, this is just to give you an idea. It is really going to be based on your specific circumstance. But you can see that you might be awarded a lot more than the Employment Standards Act, right? So in the Employment Standards Act, if you worked only 2 years, you're only going to get 2 weeks. But here, on average, if you work from 0.6 years to 2.5 years, you're almost entitled to 3 months of notice per year of service, right? So that's a significant amount more. And that's why it is really often up to a judge to decide how much that's going to be. Now, some things to keep in mind is that because this is unlike the Employment Standards Act, this is something that comes out of contract and comes out of court-based decisions. You can contract out of this. So, and oftentimes we'll see employers who will try to tell you, if we're terminating you, you're only going to be entitled to your employment standards rights. You're not going to be entitled to common law damages. And people will sign it because they don't really understand it or they don't know better. And oftentimes realistically speaking, it is hard to argue with a new employer about that. So they agree, but then when they're terminated, it can put them in a difficult position. So it's something to be aware of, to look out for when you sign contracts, right? At least you'll know what you're getting into. But there is kind of a loophole around that too, because courts acknowledge that there is a power dynamic between workers and employers. They say that if the clause is vague in any form, is not clear, could even potentially read as giving you less than your Employment Standards Act, then that clause is void. And so even if the employer thinks they're trying to contract you out of your wrongful dismissal common law damages, the court might say, well, this clause is not valid, so actually you are entitled. And I do want to hear arguments about common law damages. So that happens a lot too. So it's just something, honestly, if you're terminated, it is always best to get advice, again, prior to signing anything, right? Because sometimes employers will be like, okay, you're terminated, here's a document, sign it, then we'll give you your termination pay. And they try to force you. Just ask for some time to review it, to speak to other people. They can't deny that. And then you'll have an idea of like, okay, is what they're offering me good? Like, is it a good package? Should I try to negotiate for more? Because yeah, it sounds scary. Like I have to go to a judge to get a decision on this. Like who wants to do all of that? But we can still use these principles to negotiate with your employer. And that often does work. So, but it's best to get some fulsome advice on it. Now, when we look at wrongful dismissal damages, unlike, again, the Employment Standards Act, you also have a duty to mitigate and reduce your damages. So what that means is that after a small period of getting your bearings together, you're looking for a job, right? You're keeping track that you're looking for a job, that and you've applied for jobs, that you've been interviewing. If you look for a job and you find a job, then whenever you find your job, that might change how much common law damages you're going to get. However, if you don't look for a job, right? Sometimes workers are like, well, why would I want to look for a job then if they're going to reduce how much I get? But if you don't look for a job, the other side can make arguments, and the court has accepted that, okay, well, you didn't do your side to look for a job to reduce your damages, so I'm going to reduce your damages for you. And so you still might get, the less amount, and you still might not have a job. So it's in your best interest to look for a job. And again, that's different from the termination and severance and Employment Standards Acts, because you get those 2 weeks without any requirement to reduce your damages or to do anything. Yeah, and I did talk about this earlier. So wrongful dismissal is something that you can negotiate with your former employer, with or without the assistance of a lawyer. Obviously, it helps if you've at least spoken to a lawyer to get some initial advice about, what was in your employment contract, what was in the termination letter, what they're already offering, what you might get if you went to court. And then, if the negotiations don't work, then you do have to go to court to actually get a decision. And again, what we see is sometimes you don't get the max that you think you might get, you get somewhere in the middle. Some things to know that the small claims court claims are now up to $50,000. That happened on October 1st this year as well. And superior claim is for more than 50,000. So it's important to know this because, again, assuming you work, like depending on where you work and how long you work for, or how long you think you're going to get reasonable notice for, it might make some sense to go to small claims court, or it might make sense to go to superior court. Small claims court, if you are eligible, right, if your claim is up to $50,000, then it's easier to navigate, it's less formal, it's a little bit quicker, so you might get through it faster. Superior court has a lot of additional steps and it can be more expensive. And it's also important to know that unlike the Ministry of Labor, costs may be awarded against you if you're unsuccessful in your claim. And that's not meant to threaten you. And if you speak to a lawyer, they'll give you a lot more advice on it, but it's just meant to inform you that you have to really consider how you're approaching the situation, right? Some people get upset. Some people get upset when they don't get what they think they're expecting. Or, a lawyer might say, oh, on the high end, you might get this much, and then the settlement isn't going the way they want it to go. So it's just something to consider. Okay, so also one more thing with courts that's not related to wrongful dismissal, but as I mentioned, Ministry of Labor does do a lot of things, but sometimes when you have a number of issues, right, you have a termination issue, but you also have some Ministry of Labor issues, you might want to combine that and come to, like you might just want to handle it in one avenue at court rather than going to like the Ministry of Labor and court. So again, that's something a lawyer can give you further advice on. Okay, so now moving on to human rights. So as I mentioned, this is implied in every employment relationship, and it extends to volunteer placements as well. And you have the right to be, basically it's saying that you have the right to be free from adverse treatment or discrimination in the course of your employment on the basis of protected grounds. Now, I'll show you a list of the protected grounds in the next slide. But when we talk about course of your employment, this means through every step of your employment, right? So when you're applying for jobs, when you're interviewing for jobs, if you get hired, as you're working, and if you're terminated. And that's why I mentioned earlier that, you can't be terminated based on one of these protected grounds. And it doesn't have to be the full reason. It can just even be a part of the reason of why you're being terminated for it to trigger human right protections. The Act also includes the positive duty to accommodate your needs arising under, again, those protected needs. Protected grounds, right? So, for example, if you need a day off for religious duties, there's a positive duty on the employer to accommodate that. If you need accommodations related to a disability, related to your family, those are all, like, they have a positive duty to accommodate that. And the threshold for when they have to accommodate up until is, again, very high. Okay, the threshold is legally known as undue hardship. But what that means is that they can't just be like, well, it's not very convenient for me for you to leave early because you have to go pick up your child. Like, it doesn't matter if it's convenient for the employer or not. It is a question of what is the harm that's going to happen to the employer. And like sometimes employers will say, well, this is a very expensive accommodation, or this is a very expensive thing that I can't do this. That is also not enough of a justification, right? They have to actually investigate it. They have to have research to show, like, what is the cost? Are there grants that could be associated or help reduce the cost? Like, they have to really put in effort to show that they're not able to accommodate you. Accommodations are also a two-way street. And what that means is that if you're asking for an accommodation, you can't just expect that they're going to give you exactly what you want. You also have to um, work with them to figure out what the exact accommodation would be. So disability is, again, a good example of this one where, maybe like you have back pain, so you need more breaks, right? And you are asking for a break every hour. And then they're saying, okay, well, I don't know if we can give you a break every hour, but maybe you can take a break every 2 hours, or maybe you can take like whatever they come back with. Um, you have to genuinely think that, like, would this work? Right? Could it work that instead of every hour, you take a break every 2 hours? Um, if it could work, then you have to say yes. Like, you can't just be stuck on, no, I need this break every hour. Um, so that's just something to contemplate when we look at, you know, the duty to accommodate and like our requests for accommodation. There's also a duty to be free from harassment on any of those protected grounds as well. So the difference, or harassment, is defined as offensive behavior, comments, or insults based on one or more of the grounds of discrimination in the code. Harassment also occurs when people say something that they know or ought to know is going to make another person feel uncomfortable. So the exception to this, I mean, we kind of talked about the fact that like there's a threshold of undue hardship when we talk about accommodations, but even when we talk about adverse treatment, so discrimination, there is an exception, and that is the code will allow for it in certain situations. For example, if an employer um, can show that the reason they are discriminating against a person is because of a bona fide reason. So, a bona fide reason is a standard or practice that is adopted for the purpose that is rationally connected to the performance of the job. So for example, employees need to wear a hard hat for safety reasons, or they need to engage in some sort of protection for safety reasons. Adopted, and then the second point for a bona fide reason is that it's adopted in a good faith belief that the standard or practice is again necessary to fulfill that purpose, right? Um, so here is a list of those protected grounds. So, and then here's an example, right? So here I have a Sikh individual, Hardeep, who wears a turban as part of his religious belief. He works as a security guard. His security guard uniform includes blue pants, a white shirt, and a tie with his company logo, and a blue baseball cap also with the company logo. Hardeep tells his employer that he'll wear the pants, the shirt, the tie, but he can't wear the cap because he needs to wear his turban in public. His employer refuses his requests. Is that discrimination? So based on, what we were just talking about, that is discrimination because there is a request that I need to be accommodated because of my religious beliefs. And the employer just refused it, right? There is no investigation. There is no argument that this turban or this cap is required for a safety reason, that it's being done in good faith, and that there's nothing that could be done to kind of, accommodate Hardeep. So, I mean, the employer back, right? You could say, well, there's no safety reason for it. The employer could come back and say, no, no, the cap is there to like really identify, make sure from top to bottom you're easily identifiable, and there's safety in that. But you could say like, okay, well, is there still a way around this? Can we accommodate? Can we put the company logo on a button that can be put on his turban? Is that an accommodation, right? So you can work around what's the actual reason for why this needs to be done and what are the potential accommodations. Now, if it's just for superficial, like I just want everyone to match, well, then that's not going to pass the bona fide reason test. Now, if it was a different situation, right? If he was working on a construction site and it was a hard hat, or in a factory, I know that sometimes women who wear hijabs are told that like they need to wear a more like skin tight hijab so that there's no way it could get pulled or stuck in the machinery, right? That could be an accommodation where there's a legitimate safety concern, and then you have to work to figure out what are the possible ways to fix it. Okay, so now, if you think your rights have been violated under the Human Rights Tribunal or the Human Rights Code, you can approach the Human Rights Tribunal of Ontario with a claim. Again, you can only file it at the Human Rights Tribunal if you haven't filed it at court, because you can bring these arguments at court also. You also have to decide which one, again, is the better option. So again, sometimes, if you have a wrongful dismissal claim, but also you were discriminated against, you might want to bring both issues at court. And then similarly, if you're unionized, it might also have already been dealt with by grievance arbitration. Process is pretty simple. You have to complete a claim form. There's no fees, just like the Ministry of Labor. A court case does have fees. The time limit for human rights claim is less, though. It's 1 year from within 1 year of the violation, unless you can show that there was a pattern of violation, right? So if you're experiencing harassment at work and there was multiple instances of harassment that are all connected to each other, then the 1 year would start from the last incident, not the first incident. So a resource that exists is the Human Rights Legal Support Center. Also, most legal clinics can provide you advice on human rights issues. So I put the Human Rights Legal Support Center information, but then also SALCO and other legal clinics are available. Okay, so moving along to occupational health and safety. It's a little bit more straightforward, right? It's basically your right to refuse unsafe work, and then it's your right to be free from reprisal if you refuse that unsafe work. So reprisal is when you get punished for acting on your rights. So if you refuse unsafe work and then say you get fired, that would be a reprisal. And the Occupational Health and Safety Act says that they can't do that. So there's remedies that exist. You also have the right to be free from harassment. Now, the definition of harassment is very similar to the one in the Human Rights Code, but it doesn't have to be limited to a protected ground. So that's one thing with the Human Rights Code. We're always looking at, did the incident connect to a protected ground, right? Like gender, race, marital status. If someone is just harassing you without that protected ground reason, like they're just harassing you because you have blonde hair or, I don't know, purple hair, then the harassment would come more under the Occupational Health and Safety Act. And then you also have a right to a safe workplace, and that is an employer's positive obligation. So they have to provide you with that safe workplace. There is a complaint line, the number is on the screen. The Occupational Health and Safety Act also doesn't cover everyone, right? So it doesn't cover private residences or federally regulated employees. So it doesn't cover post office, airlines and airports, banks. And so when we look at the rights under it, we have 3 kind of big rights. So you have the right to know, which is that workers have the right to know about any possible hazards in their workplace, and employers have a duty to inform the workers about any dangers. If your workplace has between 6 and 19 rights, it may have a health and safety representative. Sorry, it must have a health and safety representative, and that is someone who you and other workers choose. They must be a worker, not a manager, and that role is to deal with safety issues in the workplace. And then the right to refuse unsafe work is then the kind of next big right. So that's basically if you think that this work that you're about to do is unsafe, is hazardous, maybe the machine hasn't been checked, you have the right to refuse that work. Your health and safety representative would come and, check, investigate. The employer would investigate. If they say that it's safe and you still don't agree, you don't have to just accept that, right? Then you can call the Ministry of Labor and have them send an investigator. You can escalate it, and you have to be paid while you're refusing to do work due to that potentially unsafe or dangerous working condition. There are some workers who can't refuse because their work is inherently unsafe. So, for example, police officers, firefighters, hospital workers, that unsafety is inherent in their work. So they can't really say no to that. So as mentioned, the harassment or definition or test is kind of similar. When someone says something or acts in a way that is known to be unwelcome, they should have known that their actions would be unwelcome. Again, it includes sexual harassment, offensive jokes, bullying, and then violence is when you use or attempted to use physical force that causes or could cause harms. And that includes verbal statements, right, or behavior that can be reasonably interpreted as a threat to exercise violence. So an employer has to have a policy on workplace violence and harassment. If there are more than 6 workers, then that policy must be in writing and has to be posted in the workplace. They also must have programs on workplace violence and harassment, and that program should include procedures on summoning immediate assistance when violence occurs, how to report incidences of violence and harassment, and procedures for investigation. Now, if your employer doesn't have a policy, they don't have those procedures, you can contact the Ministry of Labor and they'll send an investigator to look at the policy, to order the employer to make a policy, to create a policy, or to follow a policy if they have one and they're just not following it. Now, it is important to note that sometimes we get calls on, workplace violence and harassment, and it's that an employer is not following the policy or is not assisting. It's just important to note that the Ministry of Labor is limited in the fact that they can only kind of look to see if there is a policy, if it's being followed. They're not actually going to provide a remedy on the specific harassment or violence that you're experiencing. So that's just something to note. There might be other remedies, but it won't be through that specific avenue. So we're approaching the end. We're approaching the end, so bear with me. One other important aspect that wasn't in a bubble, but is important to know about when you're working in Ontario and Canada is employment insurance. So employment insurance provides benefits to individuals who are unable to work through no fault of their own. So they have a few different types of benefits, right? The main one being regular benefits. And so that is when, you're looking for work because you lost your job, again, at no fault of your own. So if you quit, you're often not eligible for regular benefits. If your employer says that you were dismissed for cause because you engaged in some form of misconduct, you might not be eligible for regular benefits. And sometimes employers will say that and you don't agree with that. There's a way to dispute it. Like EI will also kind of investigate why the employer thinks that there was misconduct, why you think there wasn't misconduct. So you can, explore that. There's also if you quit because the situation was so bad, like the harassment or the violence was so bad and you had no other choice but to quit, you might still be eligible for regular benefits, but you have to prove that you kind of took every other step, right? Like you've spoken to your boss, you've spoken to your boss's boss, you've made multiple complaints, you were looking for a job and you just haven't found one yet. But the violence and the harassment got so bad that you had to leave. You might still be eligible for regular benefits in that situation. Sickness benefits are for those who are ill or injured, and then maternity and parental benefits, again, are for those who are pregnant or have a new baby or adopted. Compassionate care benefits are for family members or close friends who are at risk of dying, and then the family caregiver benefit for parents looking after their critically ill child family members. So in order to qualify, you often need to have worked enough hours in a qualifying period, which is 52 weeks, before the start of your claim. And the number of hours you need to work is usually dependent on the unemployment rate in your region. And right now, there have been some temporary provisions because of the whole tariff situation and just the kind of overall economic situation. So you do have to keep an eye on that. Like it does keep changing. And then if you're qualified, you often get 55% of your average insurable earnings with a maximum benefit per week. And then the length also varies depending on where you live and the number of hours worked during your qualifying period. But the maximum is 45. So I kind of already, sorry, I jumped ahead. I already covered a little bit of this. So EI benefits may be denied if you quit, right? I mentioned that. There are some extreme circumstances where that's not the case. Again, if you're fired, you might be denied. Again, we talked about where there might be some circumstances, and then like against like there might be some exceptions. Disqualified, right? So that's when you don't follow instructions from EI staff. So that means you are entitled to the benefit, but then you got disqualified because EI told you to do something or attend a meeting or participate in something like a course, and you just didn't do it. And then disentitled is when you're not available to work, you're under a strike or lockout, or you didn't provide requested information. The not available to work is a really important piece of employment insurance, especially like for the regular benefits mainly. And what that means is that part of this entitlement that you receive, this benefit that you receive, you're receiving it on the grounds that you are available to work, you're looking for work, you want to work. And if they feel that you're not available to work, and oftentimes they do, they're very nitpicky and they're not like they have a lot of rules, but basically, like for example, if you were working part-time, because you had to take care of your child, and then they might question, why are you still only looking for part-time work? Right? Or if you say, oh, well, I'm looking for work, but I'm only looking for work on Mondays and Fridays because my mom's sick, they'll say, oh, you're not actually available for work. And so they'll not provide you the benefit. Again, you can make some arguments. There are some ways to show that your availability has to match your circumstance. It has to kind of match what you were doing prior. But a common one is when people go back to school, right? And they're like, they say they're still looking for a job, but they're in full-time school. So EI is a little like, well, you're not available to work. So that's just something to keep in mind, is that you have to be genuinely available to work, and you have to show it. Like you have to report that you're looking for jobs and all of that stuff. These are for regular benefits. So even if you're not qualified for regular benefits, you might still be qualified for the special benefits, which again are the sickness benefits, maternity and parental benefits, compassionate care benefits, family caregiver benefits for parents. And then, so WSIB, this provides benefits and payments for injuries and diseases related to the work that you do. So if you get injured at work, if you have developed a disease based on where you were working, that's when you might be eligible for WSIB. There are three main types of benefits: a loss of earning benefit that pays for wages you didn't get because of your injury, healthcare benefits, so they pay for healthcare costs like physiotherapy, medication, that will help you recover from the injury, and then non-economic loss. So if your injury is serious and permanent, then WSIB may pay you for the impact of that injury, which is sometimes called a permanent impairment benefit. And then they might also help with other costs, like if you aren't able to return to work, but you need retraining or education so you can do another job, they might help with that. Just in case you haven't seen already, but on TikTok and Instagram, and a little bit on Twitter, SALCO and another legal clinic have created these short videos on employment law rights. They are mainly in South Asian languages because that was the target audience for this campaign, but they're about different employment law rights and a little bit about immigration now. Okay, and that was my presentation.